on the ground. We think these structures create safety hazards. They could easily set on fire. They are not beautiful. They are unaesthetic. They are not appealing. The non-Jewish family said, you are destroying our property values because this has become a less attractive place to live if we want to sell the property because of the potential presence of these sukkahs. And the Jewish families say, stop interfering with our freedom of religion. Well, they couldn't agree, so the residential association took the Jewish families to court. The judge who first heard the case agreed with the residential association and made an order requiring the Jewish families to take down their sukkahs. The Jewish families were distressed, and they said, we're going to appeal this judicial decision, which they did, to the Quebec Court of Appeal. And the Quebec Court of Appeal agreed with the trial judge and said, you must take down these sukkahs. Even though you have freedom of religion in Quebec, what you are doing here is unacceptable in the name of religion. And the residential bylaws which you signed now force you by both way of contract and by way of your constitutional rights to respect the rights of others, non-Jewish families who live in the same complex. The Jewish families, of course, dissatisfied with the decision of both levels of court in Quebec, said we'll take the matter to the Supreme Court of Canada, the Supreme Tribunal, which they did. They appealed to the Supreme Court of Canada, and what do you think the Supreme Court of Canada said? Did they agree with the courts below that these Jewish families were in violation of the rules of the residential association and had to take down the sukkahs? Or did they agree with the Jewish families and say, your freedom of religion guaranteed under Section 2 of the Charter means that you have the right to construct and keep these sukkahs on your balconies during the period of your religious festival? The Supreme Court of Canada, which is made up of 9 judges, unlike Brazil where they have 11, the Supreme Court of Canada, by a narrow 5-4 vote, agreed with the Jewish families and said your freedom of religion was violated when the courts below ordered you to take down your sukkahs. The majority in Anselm, in the Supreme Court of Canada, used this case as an opportunity to define what religion means in Canada, and also to define the practices that freedom of religion protects. And they also, of course, had to look at the issue of whether or not, in some cases, reasonable limits can be imposed on freedom of religion. And they had to see whether this was a case where a reasonable limit was justified. The Supreme Court of Canada, interestingly, it's unlike any jurisprudence from the United States on this matter. It really does try to define what freedom of religion and religion mean. And here's their definition. And I want you to listen closely, and I'm going to point out to the number of things it does not contain. Okay. This is what religion means in Canada, according to the Supreme Court. Religion is about deeply and freely held personal convictions or beliefs connected to an individual's spiritual faith that is linked to that individual's self-definition and spiritual fulfillment. And the practices of these convictions allow individuals to foster a connection with the divine or the subject or object of that spiritual faith. Very broad, abstract definition. But here's what it does not mean. You'll notice in this definition, a person can have a religion without having to actually belong to a group. It's about an individual's spiritual faith or convictions. So religion is not something you have necessarily by virtue of belonging to a group of like-minded believers. You can be a religion of one if you choose. Second, religion, as according to the Supreme Court of Canada, is not about recognizing the authority of a particular religious leader or about embracing certain texts. So, for example, there's no mention of the Pope, there's no mention of the Bible or the Quran. There's no mention of any established church whatsoever. You can have a religion and not have doctrine, not have religious leaders, not have a church that you attend, but you can still be religious for the purposes of defining freedom of religion. Religion instead is defined as a matter of spiritual faith in which you can foster a connection with the divine. There's no mention of God. There's no mention of intermediary roles played by priests or reverends. So religion is, in the context of the Charter, a matter of sincere belief about how one connects oneself for the purpose of self-identification with the divine, and it doesn't matter whether or not there's dogma that supports it or religious officials that provide guidance. One of the reasons the Supreme Court of Canada defined religion that way in Anselm was that in the courts below, the courts accepted evidence from different rabbis about whether or not a sukkah was really justified according to Orthodox doctrine, or whether or not there could be substitutes for the sukkah. The Supreme Court of Canada said in Anselm, we are a civil court. We are a constitutional court. We are not a religious court. We're not going to decide whether this dogma is more correct than that dogma. So the court says it's mostly about individual sincere belief in terms of religious convictions, not about whether or not you are more orthodox than your neighbor. Well, having decided that this is the definition of religion, how did the court apply this in Anselm? Did the Jewish families have a sincere belief that they needed to put up their sukkahs in order to practice their religion according to what they truly believed in? Did they have this honest belief in good faith that if they could not put up their sukkah, they were in violation of their own religious convictions? And the court said, of course they believed this. It was a sincere, genuinely held belief. Nobody could doubt it. Having decided that religious freedom had been at stake in this case, the court then had to ask whether there was an interference with that religion. And the court said, of course there was. When the courts made an order saying to these Jewish families, you cannot put up your sukkah, that's a non-trivial interference with the exercise of an implicated practice or right under the Charter. What about those arguments that these things were not very appealing to look at, or that they would drive down property values? Can a court take those into account, those factors into account, in deciding whether or not there's a justification of the violation of the religious freedoms of these Jewish families? And the Supreme Court of Canada says the court should not really take economic interests or property interests, or even to some extent the impact on rights of others into account when we talk about freedom of religion. Freedom of religion should be understood generously and liberally as an absolutely fundamental right of all Canadians that should not likely be interfered with. So, in the Supreme Court of Canada, in Anselm, the Jewish families finally won, even though they had been denied victory in the other courts, lower courts, that they had initially gone to. The decision in Quebec by the Supreme Court was not popular. A lot of families, a lot of citizens of Quebec said, first of all, we think, in fact, this is going too far when Jewish families set up these kinds of structures. Secondly, the Supreme Court of Canada is giving too large and generous an interpretation of freedom of religion. They should be more concerned about the rights of co-owners in this residential complex. So that's the Anselm case. An example of the court, as I say, by definition, giving a very large amplitude to what freedom of religion means in Canada. I'm going to talk about another case now, called Mulcahy. Also from Quebec, also from the city of Montreal, but in 2006, 2 years later, there was a young teenage boy named Gurbaj Sai Mulcahy, raised in the Sikh religion. He was taught to believe, according to his religion, that having become a man, having reached the stage where he becomes a man as an early teenager, at all times he must carry or wear what's called